Welcome to Conozca sus derechos, Know Your Rights. This program is brought to you by the Hispanic Bar Association of Central Florida. It is our mission to inform our community of important legal topics affecting us all, and today we will be talking about criminal legal issues. I am Henry Lim, the Community Relations Chair of the Hispanic Bar Association of Central Florida. Today we will discuss various topics relating to criminal law. We will be discussing common mistakes and misconceptions surrounding these issues and provide information on where to go for help. During our program, we will hear from various attorneys in our community who are quite knowledgeable in the area of criminal law. Let's begin by introducing attorney Maribeth Gonzalez. Maribeth, how are you today?
I'm great.
Good. Tell us a little bit about yourself, Maribeth.
I have my law office is in downtown Orlando. I practice family and criminal law. Before becoming an attorney, I was a probation officer for Seminole County. And I just love living in Florida. I have 2 kids, and I'm here today with you discussing criminal law matters for the community.
Great. Thank you very much for being here. We truly appreciate your participation. Also with us today is attorney Jose Garcia. Jose, how are you today?
I'm great, Henry. How about yourself?
Great. Thank you, Jose, for being here today. And tell us a little bit about yourself.
My pleasure. I'm a criminal defense attorney here in Central Florida. Have been for over 8 years. I'm a participant of the Hispanic Bar Association. I'm proud to be here, and my practice is exclusively in criminal defense, so I would love to have an open conversation with you.
Great, thank you. We truly appreciate your participation as well. Let's get right to it. My child puts a toy in my wife's purse. Did my wife just commit shoplifting?
No, shoplifting, you have to have an intent to deprive someone of their property. Your child just committed shoplifting, but not your wife.
Okay. Well, technically, what is shoplifting?
Shoplifting is the intentional deprivation of someone's property without their consent.
Are there different degrees of shoplifting charges?
Well, shoplifting, it depends. It depends on the amount of the item that you stole, and it's also an enhanceable offense. And when I say amount, if you steal something from $100 to less than $300, it's a first-degree misdemeanor. If you steal something that's $305, you now committed potentially and be accused of a felony.
And what's the difference between a misdemeanor and a felony, Jose?
The sentencing, basically. As a misdemeanor, the maximum penalties you can face as a misdemeanor is 1 year, up to 1 year in county jail, whereas felonies are a year and a day and above. So anything more than a year sentence would be in prison, and that would be charged as a felony.
Maribeth, you mentioned some aggravating factors. What were you referring to? Were you referring to strictly the monetary amounts or the value of the property, or are there any other aggravating factors when determining the proper sentencing?
Besides the amount is how many times. So if you steal for the first time, it's a first-degree misdemeanor. It goes up in what you can be charged. For example, the second time, it could be a piece of gum. The amount, it's an enhanceable offense. So the more you do it and the more you're convicted of, the harsher the penalties are.
Okay. Well, what if somebody begins or presses charges against me, but then later on regrets it or changes their mind, and then they drop the charges? Can the state of Florida still try to prosecute me under criminal law?
The brief answer is yes. It's not the victim who presses charges. It's not the victim who prosecutes you. That is the job and the obligation of the state attorney's office. So it's up to them to decide what cases should be prosecuted and which should be dismissed. Obviously, if they don't have a willing and participating witness, complaining witness or victim, then it will be very difficult for them to prove their case beyond a reasonable doubt, and then they may consider dismissing the case.
And let's say that I'm arrested and I feel that the police use unnecessary force on me. What rights do I have in that situation? You
could raise a claim against a law enforcement, the law enforcement agency that you say that abused their use of force. An investigation will probably occur, and whether or not you'd win a case like that is going to be very difficult, but you do have the right to make a claim, file a report, and no law enforcement officer should be punishing or inflicting any kind of pain or unnecessary suffering on anybody.
But you should always speak to an attorney, because it might be the case where you're not the only one. There might be internal affairs investigations that are open on that same law enforcement. That happens. Sometimes people just don't speak up, or they don't know about it. We've seen on TVs where people videotape law enforcement. I mean, there's good and bad in every field, attorneys, law enforcement. So they're not an exception. There is law enforcement that do what they aren't supposed to be doing.
Does any abuse by law enforcement have any effect on any alleged criminal activity that I may or may not have been associated with?
Their credibility would be, because their testimony is evidence. Like on TV shows, they show fingerprints and DNA, but testimony is evidence. So the credibility of the police officer is going to be an issue when testifying at trial.
Why do we see sometimes that the prosecutors offer plea deals? I mean, if they have the evidence, what benefit does it concur upon the state to offer a plea deal to a defendant?
Well, sometimes it depends. It depends of their criminal history, if they have no criminal history, if they made a mistake, if there's no victims, if there's no injury. Sometimes the victim themselves say, I understand, I don't want to proceed, can you offer him a deal? So the state will work closely with the victims. If the victims don't want to proceed, like we said before, the state can still proceed, but they will take into consideration the victims. I'm not a prosecutor, so I can't speak for them, but I would imagine those are some of the reasons that will go along with that decision.
And do the courts have to accept plea deals?
They don't. They don't have to accept plea deals. However, more likely than not, if the parties have come to an agreement, most judges will take that as a disposition of the case.
Okay. We sometimes see immigrants who are facing, or non-U.S. citizens who are facing criminal charges. What should they be concerned about when dealing with these plea deals with the state of Florida?
Lately, the state of Florida has issued in the plea colloquy that the judges administer to anybody pleading to a case, they will be told that this case can deport them. And that's obviously the #1 consideration that they have to take when entering into any kind of plea deal with the state.
What are some of the requirements that are typically imposed upon a plea deal? Let's say that, what's the difference between, say, a deferred type of prosecution?
I'll give you an example with regards to plea deals without having an attorney, because since we are trying to educate the community. So sometimes you go without, if you do decide not to go to an attorney, you need to understand your rights and you need to trust your attorney. For example, for a petty theft, I just said that was an enhanceable offense. So let's say the state says, oh, a fine, an adjudication, and a fine. So you think that sounds good. Well, no, there's consequences besides that. Your license is going to get suspended. And also a conviction, you can't ever get it expunged. Had you spoken to an attorney, you might have gotten a withhold of adjudication. So with regards to plea deals, they're fine, but you should always know what you're getting yourself into, even though it sounds good, and always speak to an attorney with regards to that offer.
And how does someone qualify for a pretrial diversion or pretrial intervention, and what are those things?
Well, a pretrial diversion or pretrial intervention, they're basically the same thing, is a program administered by the state attorney's office for first-time offenders, and only first-time offenders, where it's very similar to a probation period. However, if they do complete it successfully, the state will dismiss the charges against you. So it's the ultimate outcome, but working at it from a different way.
And what's typically required in order to qualify for these pretrial diversions? What does the defendant actually have to do?
Well, you're saying after he enters into the program?
Yeah, yes.
Again, it's very similar to a probation period, so you would have to obviously stay out of trouble, report to your probation officer. There could be classes and/or community service hours that would have to be completed. but
it depends on the crime. So, for example, if you have a petty theft, you might be ordered to, you have to do the impulse control class, and you have to give a certificate. If you do the DUI, it's like being on probation. You still have to do the counter task school, the victim awareness class of 50 hours of community service. So there's requirements. The difference is the outcome. The state will totally drop the charges, and if possible, you can expunge it. If it's a qualifying offense, you can expunge it later on.
Are there any types of crimes that are more likely to be accepted by the state for pretrial intervention and pretrial diversion than others?
Well, you can't have a prior criminal history, and it's a state program, so you can't make the judge have the state give you that offer. It has to be an agreement between the attorneys, and they take the totality of the circumstances into consideration. Sometimes it may be a petty theft, and it may be something that the state is willing to give by pretrial diversion, but the state attorney might think it was egregious, or the victim doesn't agree with that, and they can move forward. So it's not something that they have to do.
Okay, great. Well, it's time for a short break. Please stay tuned as we discuss other topics in criminal legal matters. Welcome back to Conozca sus derechos, Know Your Rights, programming brought to you by the Hispanic Bar Association of Central Florida. I am Henry Lim, Community Relations Chair of the Hispanic Bar Association of Central Florida. With us today to discuss criminal legal matters are attorneys Maribeth Gonzalez and Jose Garcia. We were discussing a little bit about theft and those types of crimes. Let's talk about something that happens quite a bit in our community, and that is, let's say I find this amazing deal on Craigslist for an iPad, and I buy this iPad. A few years down the line, or maybe even a year, because these things get updated so quickly, I decide to sell it. And when I sell it, I get arrested because I was dealing in stolen property. I didn't know it was stolen. Am I in trouble?
It potentially could be, but however, the way the statute reads, you would either have to know or reasonably have known that it was indeed stolen. It really kind of depends on how good of a deal you got. Henry, you know very well that most things that sound too good to be true usually are. So if you got that iPad for $10 and he was selling them out of a van and he had 20 or 40 of them in the back of his van, chances are it's not a legitimate business, and you should be very wary of buying something like that.
But you also have a defense if you're facing trial, because maybe you thought it was a really good deal. Nowadays, a person might have been moving and wanted to get rid of their stuff. I've seen things on Craigslist like a whole office for $10 or furniture, because they just want to get rid of it. And rather than putting it outside, they just want somebody to take it. So it all depends on the facts. And at the end of the day, it's a criminal offense. So the state would have to prove beyond the reasonable doubt that you knew or should have reasonable knowledge that it was stolen.
So it's more of a use your common sense type of approach? Is that what we're talking about here?
Sounds about right.
All right. Well, let's move on to some harsher examples. Let's say that I'm driving with someone, and that person has controlled substances on their possession. Will I be arrested for possession of controlled substances? It's in the same car.
Given your example, the controlled substance was in the actual possession of somebody else in your vehicle, correct?
It was in the car.
Okay. Being in the car, the state would have to prove what's called constructive possession in order for you to be found guilty of that crime of possession. However, in constructive possession, they have to prove knowledge, that you knew that it was there, you knew what it was, and you had to have the ability to be very in close proximity to have control of that controlled substance. Those three elements are sometimes very difficult, but they do have to prove knowledge.
Well, what normally happens though out on the street? Will I be arrested? Will my passenger be arrested? Let's say that they found a joint in the back seat of the car. We have two passengers in the front seat of the car. We get pulled over for a valid traffic stop, and the police finds that the marijuana. What will happen to in that scenario? What will the police do in that scenario?
Well, in that scenario, if somebody doesn't come forward and say it's me, actually potentially everybody in the car could be arrested, because it could, if they can't prove it's yours, you can go to constructive possession. So you're talking about the back seat, so you can reach over. It's within proximity of you, so you could potentially face a charge. And
what does anything happen to my car?
If you're arrested, it could be impounded based on the fact that nobody else was there to drive it away. But yes, it could be impounded, absolutely.
Okay. Well, let's say that in another example, somewhat similar, I'm in my house and I have a roommate, and unbeknownst to me, he's growing marijuana plants in the backyard. The police find out. What's going to happen in that case? Will I be charged for possession and distributing? What happens in those types of scenarios?
Again, seek counsel immediately, because knowledge would have to be one of the primal elements that the state would have to prove, that you knew that your roommate was cultivating cannabis or some other controlled substance. And if you had no knowledge of it, yes, potentially you could be arrested. However, finding the right counsel could prevent that arrest from going any further, and obviously prevent it from becoming a conviction against you.
So you're going to you're most likely 99.99, you're going to get arrested because you're going to assume you're living in the same house, you should have known. But the state has to still prove beyond the reasonable doubt that, that you knew.
Okay. And what happens to the house? Let's say that I was the owner of the house. What happens to my house?
In the state of Florida, it's very difficult for the law enforcement to declare some form of civil forfeiture against your homestead. So assuming that that is your homestead, it'd be very difficult for them to have them forfeit your home for the purposes of committing a crime of felony in that home.
Okay. What happens in the case where there's a gun in the car? Do I have to have a concealed weapons permit to have a weapon or a gun in my car?
Not necessarily. It's a very, very good idea to lock and store your gun responsibly. They say this 3-step approach. I'd go as far as maybe 4 or 5 steps. Put it in a bag, unload it, and put it in your trunk, and put the bullet someplace else, and just make it so that you're responsible about carrying your arms.
You're supposed to conceal it, so you're supposed to have it properly stored.
Okay. Well, in the state of Florida, there's been a lot of controversy over the Stand Your Ground law. Can you guys briefly explain what this is about, the Stand Your Ground law in the state of Florida?
Well, you don't have the obligation to retreat. There's many other states that have passed this legislation where you can stand your ground. If you feel that somebody is endangering you or your life and you're in imminent threat of some kind of harm, you have the right to defend yourself. It would be carried along in a hearing prior to trial, so it's a separate issue that's heard before the actual trial itself. So the evidentiary issues would arise, and why you feel that standing your ground was your only recourse in that moment.
So if you avail yourself to this Stand Your Ground law in this separate hearing prior to trial, and let's say that you lose there and the judge says, no, you don't qualify under Stand Your Ground, are you then allowed to bring it up before the jury?
You still allow other defenses. There's still the defense of self-defense. So there are still other defenses affordable to you, and you still have the right to go to trial. It doesn't prevent you from losing any kind of pre-hearing motion or pre-trial motion. Does not prevent you from going to trial. It may have, it may prevent you from having the ultimate outcome, but you're still allowed to go to trial.
And you're supposed to be in a lawful place that you're supposed to be. So it's not like you can exercise stand your ground. I go over your house and you tell me to leave. I can't exercise stand your ground. You have to be in a lawful place where you're supposed to be.
There are limitations, in other words. Okay. When is it legal for me to voice record someone else? We see this a lot on TV programs. Is it legal to record someone's voice in the public?
It is not legal if you don't have the consent of both parties.
Okay. Even in the public?
Oh,
yeah.
go ahead.
I was going to specify that in public, yes, you don't have that expectation of privacy. However, if you're in a phone call or a phone conversation, there is a certain expectation of privacy that only those two parties are the ones listening to that conversation. And Florida is an all-party consent state, so all parties privy to that conversation have to give consent for that recording to for that conversation to be recorded.
There's different law in different states, so we're one party state. There's the other ones that we need both consents of both people, and some other states you only need, if I was calling you, if I knew that conversation was recorded as a one party and I'm okay with it, then it's okay to record it.
And how does the law apply in, let's say, video recordings? Because nowadays we have devices with us everywhere. There's even wearable devices like Google Glass where you could record by simply walking around. Are there any restrictions as far as recording?
I think that goes back to the expectation of privacy. Depends on, you know, obviously recording something in a dressing room would be different than recording something on the street. So it would depend on the situation itself.
Okay. And let's briefly talk about benefits of sealing records, because a lot of times we have people who think that they need to seal their records. What's the procedure for sealing records in the state of Florida? What are the benefits?
Well, a petition, there's sealing and there is expungement. With, let's say you entered into a plea bargain and it was a withhold of adjudication, you can seal it for 10 years and then you can get an expungement. An expungement is different. Expungement is you're expunging it from your records. For example, you first have to, if it's a qualifying offense, you first have to do an application to the Florida Department of Law Enforcement, and they will issue you a certificate of eligibility. You have no priors, you have to submit fingerprints. Once they qualify you, they'll send you a certificate. Once you get the certificate, then you have to petition to the court. That's only the first step. Then you have to submit a petition from the court. The state can object or not object. So it's not a clean cut, yes, the charges were dropped, I can expunge it. There's a process. However, you have to disclose it by statute to 5 entities. So for example, becoming an attorney, even if you expunge your records, you have to let the court know, and schools and other entities. So you always speak to an attorney with regards to that.
Well, I think that is the main lesson here, is that if you're ever facing criminal matters, that you have to seek the help of an attorney, no matter what, to protect your rights. Unfortunately, our time is up. We thank you for tuning in. I want to thank Marivette Gonzalez and Jose Garcia for their participation in Conozca Sus Derechos. The Hispanic Bar Association of Central Florida is dedicated to community service, and in our upcoming episodes, we will continue to discuss criminal legal matters and other issues important to the community at large. We wish to thank Orange TV for their assistance in bringing you this program. For further information, please visit hbacf.com. Thank you for watching, and we'll see you next time.